Book 1, Persons, Civil Personality, Chapter 1, General Provisions, Article 37. Juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effects, is acquired and may be lost. Article 38. Minority, insanity, or imbecility, the state of being a deaf-mute, prodigality, and civil interdiction are mere restrictions on capacity to act and do not exempt the incapacitated person from certain obligations, as when the latter arise from his acts or from property relations, such as easements. Article 39. The following circumstances, among others, modify or limit capacity to act: age, insanity, imbecility, and state of being a deaf-mute, penalty, prodigality, family relations, alienage, absence, insolvency, and trusteeship. The consequences of these circumstances are governed in this code, other codes, the rules of court, and its special laws. Capacity to act is not limited on account of religious belief or political opinion. A married woman 21 years of age or over is qualified for all acts of civil life, except in cases specified by law. Chapter 2. Natural Persons. Article 40. Birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Article 42. Civil personality is extinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. Article 43. If there is a doubt, as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to the other. Chapter 3. Juridical Persons. Article 44. The following are juridical persons. 1. The state and its political subdivisions. 2. Other corporations, institutions, and entities for public interest or purpose, created by law. Their personality begins as soon as they have been constituted according to law. 3. Corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from that of each shareholder, partner, or member. Article 45. Juridical persons mentioned in numbers 1 and 2 of the preceding article are governed by the laws creating or recognizing them. Private corporations are regulated by laws of general application on the subject. Partnerships and associations for private interest or purposes are governed by the provisions of this code concerning partnerships. Article 46. Juridical persons may acquire and possess property of all kinds, as well as incur obligation and bring civil or criminal actions in conformity with the laws and regulations of their organization. Article 47. Upon the dissolution of corporations, institutions, and other entities for public interest or purpose mentioned in number 2 of Article 44, their property and other assets shall be disposed of in pursuance of law or the charter creating them. If nothing has been specified on this point, the property and other assets shall be applied to similar purposes for the benefit of the region, province, city, or municipality which during the existence of the institution derive the principal benefits from the same. Title II. Citizenship and Domicile. Citizenship, amended by Article 4, Section 1 of the 1987 Philippine Constitution. Article 48. The following are citizens of the Philippines. 1. Those who were citizens of the Philippines at the time of the adoption of the Constitution of the Philippines. 2. Those born in the Philippines of foreign parents who before the adoption of said Constitution had been elected to public office in the Philippines. 3. Those whose fathers are citizens of the Philippines. 4. Those whose mothers are citizens of the Philippines and upon reaching the age of majority elect Philippine citizenship. 5. Those who are naturalized in accordance with law. Article 49. Naturalization and the loss and reacquisition of citizenship of the Philippines are governed by special laws. Article 50. For the exercise of civil rights and the fulfillment of civil obligations, the domicile of natural persons is the place of their habitual residence. Article 51. When the law creating or recognizing them or any other provision does not fix the domicile of juridical persons, the same shall be understood to be the place where their legal representation is established, or where they exercise their principal functions. Titles 3 to Title 9 were repealed by Executive Order Number 209, otherwise known as the Family Code of the Philippines. Title 10. Funerals. Article 305. The duty and the right to make arrangements for the funeral of a relative shall be in accordance with the order established for support under Article 294. In case of descendants of the same degree, or of brothers and sisters, the oldest shall be preferred. In case of ascendants, the paternal shall have a better right. Article 306. Every funeral shall be in keeping with the social position of the deceased. Article 307. The funeral shall be in accordance with the express wishes of the deceased. In the absence of such expression, his religious belief or affiliation shall determine the funeral rites. In case of doubt, the form of the funeral shall be decided upon the person obliged to make arrangements for the same, after consulting the other members of the family. Article 308. No human remains shall be retained, interred, disposed of, or exhumed without the consent of the persons mentioned in Articles 294 and 305. Article 309. Any person who shows disrespect to the dead or wrongfully interferes with the funeral shall be liable to the family of the deceased for damages, material and moral. Article 310. The construction of a tombstone or mausoleum shall be deemed a part of the funeral expenses and shall be chargeable to the conjugal partnership property if the deceased is one of the spouses. Title 11. Parental Authority is also included in the Family Code of the Philippines. Title 12. Care and Education of Children. Article 356. Every child is entitled to parental care. Shall receive at least elementary education. Number 3. Shall be given moral and civic training by the parents or guardian. Number 4. Has a right to live in an atmosphere conducive to his physical, moral, and intellectual development. Article 357. Every child shall 1. Obey and honor his parents or guardian. 2. Respect his grandparents, old relatives, and persons holding substitute parental authority. 3. Exert his utmost for his education and training. 4. cooperate with the family in all matters that make for the good of the same. Article 358. Every parent and every person holding substitute parental authority shall see to it that the rights of the child are respected and his duties complied with, and shall particularly, by precept and example, imbue the child with high-mindedness, love of country, veneration for the national heroes, fidelity to democracy as way of life, and attachment to the ideal of permanent world peace. Article 359. The government promotes the full growth of the faculties of every child. For this purpose, the government will establish whenever possible 1. Schools in every barrio, municipality, and city where optional religious instruction shall be taught as part of the curriculum at the option of the parent or guardian. 2. Periculture and similar centers. 3. Councils for the protection of children, and 4. Juvenile courts. Article 360. The Council for the Protection of Children shall look after the welfare of children in the municipality. It shall, among other functions, 1. Foster the education of every child in the municipality. 2. Encourage the cultivation of the duties of parents. 3. Protect and assist abandoned or mistreated children and orphans. 4. Take steps to prevent juvenile delinquency. 5. Adopt measures for the health of children. 6. Promote the opening and maintenance of playgrounds. 7. Coordinate the activities of organizations devoted to the welfare of children and secure their cooperation. Article 361. Juvenile courts will be established as far as practicable in every chartered city or large municipality. Article 362. Whenever a child is found delinquent by any court, the father, mother, or guardian may in a proper case be judicially admonished. Article 363. In all questions on the care, custody, education, and property of children, the latter's welfare shall be paramount. No mother shall be separated from her child under 7 years of age, unless the court finds compelling reasons for such measure. Title 13. Use of surnames. Article 364. Legitimate and legitimated children shall principally use the surname of the father. Article 365. An adopted child shall bear the surname of the adopter. Article 366. A natural child acknowledged by both parents shall principally use the surname of the father. If recognized by only one of the parents, a natural child shall employ the surname of the recognizing parent. Article 367. Natural children by legal fiction shall principally employ the surname of the father. Article 368. Illegitimate children referred to in Article 287 shall bear the surname of the mother. Article 369. Children conceived before the decree annulling avoidable marriage shall principally use the surname of the father. Article 370. A married woman may use 1. Her maiden first name and surname, and add her husband's surname, or 2. Her maiden first name and her husband's surname, or 3. Her husband's full name, but prefixing a word indicating that she is his wife, such as Mrs. Article 371. In case of annulment of marriage, and the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may resume her maiden name and surname. However, she may choose to continue employing her former husband's surname unless 1. The court decrees otherwise, or she or the former husband is married again to another person. Article 372. When legal separation has been granted, the wife shall continue using her name and surname employed before the legal separation. Article 373. A widow may use the deceased husband's surname as though he were still living, in accordance with Article 370. Article 374. In case of identity of names and surnames, the younger person shall be obliged to use such additional name or surname as will avoid confusion. Article 375. In case of identity of names and surnames between ascendants and descendants, the word junior can be used only by a son. Grandsons and other direct male descendants shall either 1. Add a middle name or the mother's surname, or add the Roman numerals 2, 3, and so on. Article 376. No person can change his name or surname without judicial authority. Article 377. Usurpation of a name and surname may be the subject of an action for damages and other relief. Article 378. The unauthorized or unlawful use of another person's surname gives a right of action to the latter. Article 379. The employment of pen names or a stage name is permitted, provided it is done in good faith and there is no injury to third persons. Pen names and stage names cannot be usurped. Article 380. Except as provided in the preceding article, no person shall use different names and surnames. Title 14. Absence. Chapter 1. Provisional measures in case of absence. Article 381. When a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property, the judge, at the instance of an interested party or relative, or a friend, may appoint a person to represent him in all that may be necessary. This same rule shall be observed when under similar circumstances the power conferred by the absentee has expired. Article 382. The appointment referred to in the preceding article having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee, and shall specify the powers, obligations, and remuneration of his representative, regulating them according to the circumstances by the rules concerning guardians. Article 383. In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. If the absentee left no spouse, or if the spouse present is a minor, any competent person may be appointed by the court. Chapter 2. Declaration of Absence. Article 384. 2 years having elapsed without any news about the absentee, or since the receipt of the last news, and 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. Article 385. The following may ask for the declaration of absence: 1. The spouse present. 2. The heirs instituted in a will, who may present an authentic copy of the same. 3. The relatives who may succeed by the law of intestacy. 4. Those who may have over the property of the absentee some right subordinated to the condition of his death. Article 386. The judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. Chapter 3. Administration of the property of the absentee. Article 387. An administrator of the absentee's property shall be appointed in accordance with Article 383. Article 388. The wife who is appointed as an administratrix of the husband's property cannot alienate or encumber the husband's property or that of the conjugal partnership without judicial authority. Article 389. The administrations shall cease in any of the following cases: 1. When the absentee appears personally or by means of an agent. 2. When the death of the absentee is proved and his testate or intestate heirs appear. 3. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases, the administrator shall cease in the performance of his office, and the property shall be at the disposal of those who may have a right thereto. Chapter 4. Presumption of Death. Article 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes except for those of succession. The absentee shall not be presumed dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an airplane which is missing, who has not been heard of for 4 years since the loss of the vessel or airplane. 2. A person in the armed forces who has taken part in war and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances, and his existence has not been known for 4 years. Article 392. If the absentee appears or without appearing his existence is proved, he shall recover his property in the condition in which it may be found, and the price of any property that may have been alienated or the property acquired therewith, but he cannot claim either fruits or rents. Chapter 5. Effect of absence upon the contingent rights of the absentee. Article 393. Whoever claims a right pertaining to a person whose existence is not recognized must prove that he was living at the time his existence was necessary in order to acquire said right. Article 394. Without prejudice to the provisions of the preceding article, upon the opening of a succession to which an absentee is called, his share shall accrue to his co-heirs, unless he has heirs, assigns, or a representative. They shall all, as the case may be, make an inventory of the property. Article 395. The provisions of the preceding article are understood to be without prejudice to the action of petition for inheritance or other rights which are vested in the absentee, his representatives or successors in interest. These rights shall not be extinguished save by lapse of time fixed for prescription, in the record that is made in the registry of the real estate which accrues to the co-heirs. The circumstances of its being subject to the provisions of this article shall be stated. Article 396. Those who may have entered upon the inheritance shall appropriate the fruits received in good faith, so long as the absentee does not appear, or while his representatives or successors in interest do not bring the proper actions. Title 15, Emancipation and Age of Majority, is also repealed, otherwise known as the Family Code of the Philippines. Title 16, Civil Register. Article 407, Acts, Events, and Judicial Decrees concerning the civil status of persons shall be recorded in the Civil Register. Discussion on persons, reference Aquino. Natural persons, birth determines civil personality, exception, presumptive personality. A conceived child has to be considered born for all purposes that are favorable to it, provided it be born alive. Taken from 1991 and 1999 bar. Examples: donation to a conceived child or given before birth is valid provided it is born under the conditions provided for under Article 41 of the new Civil Code. This is given 2012 and 2014 bar. Number 2. The onboard child may also be the designated beneficiary in an insurance policy under the same conditions. 2008 bar. Characteristics of presumptive personality: 1. It is limited, and 2. Provisional or conditional because the child must be born alive. The action for damages of a husband against an abortionist may prosper with respect to his own damage. Moral damages, like the unborn child whose personality never existed, may not be entitled to damages for breach of his right to life and dignity. 2003 and 2011 bar. When a child is considered born, for civil purposes, the fetus with intrauterine life of at least 7 months is considered born if it is alive at the time it is completely delivered from the mother's womb. 1953, 1957, 1999, 1991, and 2012 bar. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Extinguishment of civil personality. Civil personality is extinguished by death. Presumptions on survivorship. If there is a doubt as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to the other. Presumed to have died at the same time. Thus, the relatives shall be presumed to have died at the same time if the following requirements are present. This appeared in 1998, 1999, and 2000 bar. There is a doubt as to who died first. The parties are heirs of each other. They are called to succeed each other, and there is no proof as to who died first. Rule 131, Section 3, under JJ of the Rules of Court applies if the person involved are not heirs of each other. On domicile, for the exercise of civil rights and the fulfillment of civil obligations, the domicile of natural person is the place of their habitual residence. Juridical person, its domicile is its principal office appearing in its articles of incorporation. When the law creating or recognizing them, or any other provisions, does not fix the domicile of juridical persons, the same shall be understood to be the place where their legal representation is established, or where they exercise their principal functions. Citizenship, Article 4 of the 1987 Constitution. Naturalization and loss and reacquisition of citizenship of the Philippines are governed by special laws, including Commonwealth Act numbers 63 and 473, PD numbers 725, and RA numbers 530, 8171, and 9139. Elements of domicile. The person must be physically present in a fixed place. Number 2, animus manendi. There must be intent to remain there permanently. Kinds of domicile. Domicile of origin is assigned by law to a person at birth. Domicile of choice, the place chosen by a person who does not suffer any legal disability. And constructive domicile, or domicile by operation of law, assigned by law to a child who is suffering from legal disability at the time of his birth, or also in one of change of domicile arising from marriage, also called domicilium necessarium. Distinguished from residence, residence involves factual relationship of an individual with a certain place. It is the physical presence of a person in a given area, community, or country. If the intent of the person is to remain in the residence, then it becomes the domicile. Laws sometimes use the words residence and domicile synonymously. For example, when election, suffrage, and naturalization laws use the term residence, the term is invariably used synonymously with domicile. However, there are also cases when it is important to know the distinction between residence and domicile. For example, residence for purposes of applying the rules and venue for filing civil cases is not synonymous with domicile.